Oh yes, yes, that's it. I mean, yeah. Thank you.
ये कहाँ ये मतलब हाँ, ये तुझे भी आएगा हाँ मेरे को नहीं हाँ किसको सबको
Hello. Good afternoon. Am I audible?
Yes, Priya, you are
Maheshi,
audible. You are
I
audible.
can't hear you.
टिंगलिंग दिया आपने
Can't hear you. Maheshi can't hear you. Hi Faizan, I can hear you.
आपने ले लिया ज्वाइन हुआ
Thank you.
मैं रजिस्टर ही नहीं किया था
Now you can hear?
Yes, perfect.
Yes.
We can see you for sure.
Okay. Who is Linda? Okay.
उसकी ज्वाइन नहीं किया
Let others enter us straight away. Don't wait for 2:30 because there will be a lot of rush. Better allow them to enter. There's nothing wrong.
Yeah.
Priya, tell what other people also will join all these. Shreya and
Yeah, it's
Shamika.
already here. They're
It is
joining.
required. Yeah, because she is not the other two people.
Yeah, I think Shreya is already here.
Hmm.
Shamika will also come.
Raman may not join because he is on TV.
Yeah.
Okay. Better FIDC there everywhere.
Good morning, sir. Good morning, ma'am. This is Ronak from Motilal Oswal Home Finance team.
Great.
Hi,
Good
hi,
afternoon.
Ronak. Good afternoon.
Um,
We'll start at 2:35, maybe. I don't know, subject to 2-3 minutes. It will be to give.
Hi Priya, good afternoon.
Hi, good afternoon. There's a message on the chat saying they're not able to hear us.
Hi Mahesh ji, good afternoon.
Good afternoon.
अरे नाटक कर रही लड़की रेड हो गई पूरे दांत में कीड़े आ करो ऐसे आ करो आ पूरे दांत में कीड़े लग गए भैया रोज चॉकलेट खा रही हो
I
क्या
think we'll
दादी
have
से
to force mute everybody.
Yeah. Some dentist is there on message.
We'll have to force mute everyone.
Yeah.
Vrinda ma'am, just try to see if we can just force mute everyone.
Yeah, we'll do that. Yeah.
Accidentally also somebody might hit their unmute.
Faizan, can you mute everyone?
It's already done.
Okay.
We'll just wait for a couple of minutes more. It's muting me also, Faizan, automatically.
Yeah, because it will only leave the organizer aside. So let me leave the organizer.
But how will the others speak then?
So manually unmute. It is possible to unmute and speak.
Okay, because it was forced again going into mute. No problem. I think this is fine. No, so for those who have joined us, we'll just wait for a couple of more minutes. We have got close to 200 registrations, and I can see the count currently is about 50. It's going up every second. So as soon as we hit a 75 mark, I think we can kickstart. Fazan, can you just check? Maheshji is saying he's not able to unmute himself. If somebody from the back end can just see if there's any setting, post setting. Mahesh Thakkar, if you can just help allow him to unmute. I'll just cue him in. Okay. I think we'll start.
He should be able to. He has the right to unmute manually. We have not disabled it here. Yeah, the way you are able to mute and mute yourself, everyone else should be able to do that.
Great. Okay. Let's start. We have about 80 people now. So good afternoon, everyone. Thank you for joining us to this crucial awareness session on the Digital Personal Data Protection Act 2023, jointly organized by FIDC and PwC. As the RBI recognized self-regulatory organization for the NBFCs, FIDC is committed to keeping our members up to date about the regulatory developments that impact our sector. The DPDP Act represents a landmark shift in how we handle customer data, and with the final rules that have just been notified as recently as 13th November 2025, it's very essential that we understand our obligations and prepare ourselves for implementation. Now, before we explore the technical aspects with our facilitators from PwC, I would like to invite our chairman, Mr. Mahesh Thakkar, to set the context and share his perspective on the importance of DPDP compliance for the NBFC sector. Over to you, sir. Can you try to unmute Fazan? The admin can unmute him, I think. Yeah. Yes, sir.
Yeah, can you hear me now?
Yes, sir.
Yeah, good afternoon, friends. Welcome to this, webinar, second in the row. We had one on co-lending last month, and that time we promised that before March we will have 4 more some educative and training workshops, webinars, etc. in consultation with all our partners like PwC and other legal firms and chartered accountant firms, consulting firms. It's a goodwill of FIDC that these people are helping us, and it's thanks PwC for all this help. In fact, in last 20 years, PwC has done Kamdi and another group, not only in these webinars, but also in representations when we draft to provide the data, value additions, and the logics and arguments which we have to give it to the authorities. Friends, before we go to the actual subjects, I wanted to share to the last 48 hours, FIDC has met Finance Minister twice. We met 17th November in Delhi, and we talked to her about entire SRO concept, which are, to acquaint her what we are doing as an SRO, what our plans as the commitments given to the Reserve Bank of India and the docket which we have submitted to RBI, and how we will carry forward entire agenda of compliance, governance, regulation, code of conduct, trainings, webinars, workshops, membership drives, committees, board of directors, independent directors, everything she heard for 15 minutes, and she was very happy to learn that now NBFC sector has been recognized by RBI and it will be falling in streamline. And we talked of only one issue, funding. All other issues are being debated today. In fact, we had another meeting at 11 o'clock, pre-budget meeting today at 11 o'clock, where we talked about TDS, SARFAESI, KYC and funding issues in detail. But on that day, we talked only about funding. We said that only if funding is taken care of, we will see that everybody falls in line. And for the small and medium NBFCs, base layer NBFCs, we will take care of the trainings, webinars, workshops, etc., so that the governance standards are maintained. And we will reach to the target which is specified in the symposium in July 2025, that we need to double our targets and our goals to reach 48 lakhs crores, 50% of the bank lending in India. So let's see how we can achieve this. With support of all of you, we should be able to do that. And we'll keep on, having such webinars, telling you about what is the progress every 2 months about this SRO, about the code of conduct and the membership agreement which are under drafting. And maybe in the first week of January or so, Priya will come back to you with detailed webinar training. And the most important webinar will be on the how to give data to the FIDC. That we will be doing more than 12 such webinars in next 3-4 months at various centers. So far so about this. And of course, we are in touch with RBI. And we are very soon having a meeting, maybe next fortnight, with the governor to acquaint him with all these details and to invite him as a chief guest at our mega event, which is likely to happen in Bombay in last week of December or first week of January. Let's come to the subject. Of course, I'm not going in the subject because Priya has mentioned and she will talk about it. This is a very important act, and every NBFC banks institution will have to be careful about sharing of the data, etc. So PwC team will of course talk about the entire context. What is it in store for NBFC, what it means for them, and what all privacy tools which we'll have to take care of. So let's go into the. In fact, I will learn more than 90% of things which they are going to talk will be new for me. So I'll also enjoy learning with you people. And of course, at the end will be the interactive session. Do take advantage. Put your queries in the chat. All the best to all of you. Back to Priya.
Thank you, Maheshji, for that insight that you gave in just a few minutes to all our members here. Now let's dive into the practical implications. We're privileged to have PwC's privacy and data protection experts with us today. They've been working very closely with the financial institutions on DPDP readiness, and today they will walk us through what this means specifically for our NBFCs. We have from PwC with us today Mr. S. Dinesh, partner at PwC India, leading the cybersecurity and digital risk practice for the financial services sector with over 15 years of experience. He specializes in data privacy governance and regulatory compliance, helping financial services transform IT risk and compliance functions using next-gen technology solutions. Currently, he's leading 15 plus DPDP implementation engagements. We also have with us Ms. Vindawag, partner in the PwC's risk consulting practice for the past 3 years, focusing on regulatory compliance in the FS sector to ensure they are compliant and applicable regulations. Prior to joining PwC, Vinda was also the Group Chief Compliance Officer for a large financial service group and has been interacting regularly with the regulators. Mr. Faizan Sarwar will be leading the conversation and this discussion today, who's Director in PwC India Cybersecurity and Digital Risk Practice for the Financial Sector Service. He has over 13 years of experience and specializes in data privacy, IT risk, and cybersecurity audits, leading multiple DPDP compliance engagements for banks, insurers, and NBFCs. Faizan is currently managing about 5+ DPDP implementation for financial services clients. Faizan will be supported by Satya Rautre and Kushagra Sharma, who are also part of the data privacy practice in PwC India. Now, without further ado, I will hand over the session to PwC team. I definitely encourage each one of you to participate actively and ask as many as questions as you can. Do use the chat window very effectively. Post your queries, and we will try to cover as many queries as we can in our session today. Over to you, Faizan.
Thank you. Thank you. So thank you, first of all, thank you, Mahesh, sir, for sharing a vision with us about the NBFCs. And thank you, Priya, for the introduction. I'll take it forward from here. So before I start, I just wanted to mention that if there are any questions during the course of this discussion, please feel free to put them on the chat. We will take it as we go forward, or we will take it towards the end when we have a dedicated time period just to address any questions that comes our way. Okay. Otherwise, you can raise your hand and also ask the question, but preferably let's put it in the chat so that we start our conversation. So for today, as we all know, that we are here to focus on the Digital Personal Data Protection Act, which is basically one of the hottest topic of discussion across sectors, across industry in the country today. The reason being the act had been notified on a few days back by the government, and it is applicable now. So as a result, organizations operating in India are basically striving to ensure that they achieve compliance as soon as possible. So the objective of today's discussion is to make you all understand what does the act entails, what is the expectation from various requirements which is outlined in the act. And in this context, what we have done is we have prepared a small presentation where we will first set the context in terms of helping you understand what is data privacy. While the name of the act says Digital Personal Data Protection Act, it entails a lot of privacy related concepts. Hence, we need to understand what privacy is, and hence therefore the data protection aspects would follow through. How it impacts the NBFC is again something that we would want to discuss, and subsequently we would want to give an overview of the data privacy tools which are currently available in the market, and followed by the last section where we will basically there are a few questions that you would want to ask to clarify your understanding of the overall concepts, and then subsequently we will take a few questions which we may have if time permits. So that in a nutshell is about the agenda that we have for today. Moving forward. So let us first try and understand what is data privacy. I think there is an echo here. Sorry. So let us first understand what is data privacy. So basically, data privacy is about rights of individuals, rights of people like us, you and me, who have personal data. So our names, our phone numbers, our email IDs to start with, and there are a lot of other parameters which I will be covering at a later stage. They all helps identify an individual uniquely, and protection of the personal data is one of the obligations of organizations who are collecting it. So privacy is about rights of individuals, and it is also about obligations of organizations, so that data or personal data of individuals remains protected and is only processed based on their consent. So data privacy basically entails four aspects as to how data will be used, how data is shared, what is the type of data that is basically processed, and who is accountable for processing. These four considerations are taken into consideration whenever we talk about data privacy related concepts. Okay, so to understand it a little bit more, what does data privacy focus on? Data privacy is there across the world. Data privacy actually focuses on governance around usage of personal data. As of today, while India's Data Privacy Act only went live a few days back, but as of today, there are more than 137 countries who has their own data privacy related laws. So it's not that India has been one of the is on the forefront of implementing a data privacy law or coming up with a law, but this has been identified or recognized as a need quite long ago, that there is a that we need to protect personal data, or organizations needs to protect personal data, and hence comes the obligations for organizations as to what they need to do. The Act basically summarizes what are the responsibilities of organizations who are covering or who are capturing personal data and then subsequently processing personal data of individuals. So that in a nutshell is about data privacy. I'll quickly move forward to understand what is the need to have a data privacy and data protection related regulation in a country. So the one of the key requirements, while we are in this digital age, there are multiple touch points. There are multiple applications and touch points where we actually end up sharing our personal data. And once we have shared our personal data, how that data is processed, there is no control over it. What happens after that? If there is no control over it, uh, chances are that the particular personal data that is shared is misused to basically misused to increase surveillance, to profile an individual as to what are the preferences and choices that an individual may have based on the personal data that is being shared. And you would come across so many scenarios where there is an identity theft going on. Someone is impersonating to be someone else. All of this is only possible when a fraudster have access to an individual's personal data, because in the absence of an individual's personal data, it might not be possible to impersonate someone and thereby lead to certain frauds. So, because these threats were increasing due to the adoption of digital technologies across the country, it became a need to have a data privacy regulation within the country, and hence thereby the act has been formalized. I am going to take you through the overall maturity of the act as to how the act came into the picture today. What was its journey in India, so that it will give you a clear picture that since when discussions around data privacy has started within the country, and while we see it today that it has now been notified and it has now been become applicable. But before we do that, let us take a quick look at what is a personal data, and specifically in the context of NBFCs. So personal data, first of all, is a data element or a group of data elements which will help identify an individual uniquely. So for example, if we have to say that PAN number or Aadhaar number, these are some of the easiest of examples to quote, which will help us identify an individual uniquely. So if if we know a PAN number, we probably will be able to identify who that person, whose PAN number that particular is, without the need to have any other detail. However, similarly, it is the case with mobile numbers also, that we don't need to know any other details to identify an individual if we know the mobile number. But if I have to talk about, say, our name and date of birth, these two together while a name individually may not be enough to identify an individual, there can be so many people with the same name. However, same name, same surname as well. However, the moment we tie back this information with another element, say an address or say an age, we will be able to then identify individuals uniquely. And that is the reason why I mentioned that personal data is either a single element which helps you identify an individual uniquely, or a combination of elements which helps you identify an individual uniquely. But till the time you are able to identify an individual uniquely, all of those combinations or elements which are forming part of those combinations would be part of the personal data that an organization is processing. And hence the act, the DPDP Act would apply if any such if organizations have these information which they are processing. Now, I'll take a quick pause here to understand if there are any particular question which is coming our way through the chat. How can we classify personal data? Whether name is personal data, what are the personal data that needs to be encrypted? Okay, so Sajid, to answer your question on this particular topic, is there a need to classify a personal data from an act perspective? First of all, no. There is a need to identify which all data elements is personal in nature, and my slide here gives you an indication as to what all personal data entails. However, what is there a need to encrypt personal data? Of course, there is a very specific requirement in the rules that was released, which to be very specific, it is Rule 6, which says that the security controls has to be implemented, and one of the ways to implement security controls is encryption. So, a personal data is required to be encrypted. Is there is the act clear about what personal data you can encrypt and what you should not be encrypting? The answer is no. There is no such provision in the act which segregates within personal data if there is a need to do an encryption or not. Also, I want to highlight one more thing. Subsequently, when we look into the act, we'll also get to know that unlike other acts, similar privacy and data protection acts which are popular, for example, GDPR, for example, CCPA, GDPR, which is applicable in the European Union, or CCPA for California, there are provisions in those regulations which mentions that beyond personal data, there is a segment called sensitive personal data. Okay. However, in India, as part of the DPDP regulation, there is no such segregation in place. There is only one definition in terms of from a coverage perspective, and that is whatever falls under the purview of personal data would be part of the scope of the DPDP. Okay. Which personal data are encrypted? As I think I have answered this question, that there is no need to basically, there is a need to encrypt personal data, but there is no segregation that you should be encrypting one or you should not be encrypting two. It is left to the organizations to decide as to how they want to implement reasonable security safeguards, which will help protect the data. Okay, I'll move forward. So I'll start with the evolution of the DPDP Act. So when I start with the evolution of the DPDP Act, let me highlight one critical aspect, that on August 24th, 2017, the Supreme Court of India, while it's one of its landmark ruling, made data privacy a fundamental rights of citizens of India, of individuals in India. So privacy is a fundamental right, and it was declared by the Supreme Court of India back in 2017. We are talking about 8 years from now, more than 8 years from now, this has been identified. So once the privacy was identified as a fundamental right, there was Justice B.N. Krishna committee that was formed to do a research and come up with a report on the requirements of privacy. And the report was published subsequently in 2018. The report is named as Free and Fair Digital Economy. It talks about the modern data protection framework that needs to be adopted by India to ensure that the fundamental rights of individuals when it comes to privacy is protected. That was the stepping stone for the DPDP Act that we have today. Subsequently, in 2019, the government introduced a personal data protection bill. It was a hugely debated bill named as PDP bill. In that bill, basically, the government introduced a concept of data protection authority, or they would be the regulators who will then take decisions as to what all data protection related and data privacy related requirements should be implemented. So this bill was largely immensely debated, fiercely debated in both houses of parliament. However, in 2022, it was decided that the bill needs much more rework, needs to be made simpler, and a much focused framework which is implementable in India. And hence that bill was withdrawn in 2022. With the bill withdrawn, immediately the government also clarified that they will come up with a revised bill, and that particular revised bill was introduced in 2023 itself, and then that particular bill was passed by the parliament, and hence it became an act that we are now, which is now referring to Digital Personal Data Protection Act. So the DPDP Act was basically passed by the Parliament August 2023 in the monsoon session. The Act had 22 provisions with 7 schedules. These 22 provisions, out of these 22 provisions, there are some 8 or 9 provisions, if I'm not wrong, which are specific to organizations which are operating in India. They need to be those 8 or 9 provisions basically focuses on what the organizations needs to do to comply to the act. What are the expectations from the act? There are certain set of provisions which basically were outlined for establishment of the regulator, and this time the regulator was Data Protection Board. The act outlined that there will be a regulator which will be established, who will be responsible for enforcement and implementation of the act. So from 2023, many organizations started their compliance journey, given that it was already passed by the parliament. However, the rules were never notified until last Friday. What does the notification of rules mean? Notification of rules basically means that what is the timeline of compliance? The rules would basically come up with a compliance timeline, which would say by when organizations are required to ensure that they are compliant to the act. In addition to the compliance timeline, the rules would also clarify any open conditions which were not self-explanatory in the act. So before releasing the final rules on 3rd of January 2025 or 4th of January, if I'm not wrong, the government released a draft version of the rules, and the draft version of the rules was released with a caveat that this will come. There will be public consultations that will be done across all industry sectors. And then subsequently a final rule will come. A 45-day period for public consultation was provided, which was subsequently extended by another 15 days, wherein all organizations were expected or were requested to provide to go through the rules and submit a response or request for clarifications. So more than 7,000 responses were submitted as a part of the public consultation that was done on the rules, on the draft rules. And taking into consideration the the responses that were submitted, the government has now, on last Friday, notified the final rules of the DPDP Act with an implementation timeline. So we will talk about the implementation timeline in further details, but just to summarize, the rules which has been notified, the final rules has 22, there are 23 rules and 7 schedules. Again, these 23, each of these 23 rules map back to the provisions in the Act, which was basically finalized in 2023, the DPDP Act, and they provide clarity in terms of how these rules or how what should be the compliance approach to each of the provisions which are there within the Act. So this, in a nutshell, is about how the DPDP Act evolved. It all started with BN Krishna Justice BN Krishna Committee's report, along with Supreme Court, basically identifying data privacy as a fundamental right of citizens of India. I'll move forward. So what I have done is I have here I'm trying to basically talk about what are the nuances which are there within the Act and the rules. First and foremost, on whom does the Act applies to? Let us try and understand. So there are two qualifying criteria. So for organizations operating within the territory of India, processing digital personal data, and providing services, goods and services in India, to all of these organizations, the rules apply to. However, as the name of the Act entails, it is Digital Personal Data Protection Act. So if an organization is processing data which is not in a digital form, which is in a physical form, then the Act does not fall under the purview of such organizations. But today, in this digital age, every organization is processing some or other form of personal data in digital form. Hence, there will hardly be an organization which will not fall under the purview of the Act. So, data in digital form, to be specific, is something that all of us need to be mindful of, that because it falls under the purview of the Act. And personal data, if collected in non-digital form but digitized subsequently. So for example, if we have an account opening form or we have a loan application form, and other processes are designed in such a way that a manual form has to be filled in by a customer, then someone from the organization picks up that particular form and digitizes the data, puts into a software, then or in all such scenario, the Act would apply equally. So it is either the data is either collected in digital form or collected in non-digital form but digitized subsequently. In all these scenarios, the Act would apply. The Act would also apply to those organizations who are operating from outside the Indian territory. However, they are providing goods and services to data principals or to customers in India, then the Act would again apply equally. So these are largely the two qualifying criteria for an organization to be applicable to the Act. What does the Act what are the scenarios where the Act does not apply to? The Act does not apply to any personal interaction that we have, say over an SMS or over a WhatsApp chat or over a phone call where we are sharing some personal information between. Then in all such scenarios, the Act would not apply. Any personal data which is available publicly on all those data sets also, the Act would not apply. Okay, if a personal data is available publicly, there are so many scenarios where on some websites, on some government websites, there is some notification published where certain personal data has been made public. And another organization is picking up that those personal data which has been made public to provide goods or services, then the Act would not apply. The provisions of the Act would not apply on all of those scenarios. Okay, then obviously the third piece is that if there is a person who is under an obligation under any law for a brief period of time in force in India to make such personal data publicly available, then again the act would not apply. If there is a statutory requirement on an individual, or there is a legal proceeding which is making an individual uh, 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 make some personal data available, then the act would not apply in those scenarios. So this, in a nutshell, is on the act from an applicability perspective. As we all know, that the final rules were released last Friday. I just wanted to give a sneak peek into what the rules entail. Did mention earlier that there are 23 rules which are there in the submission. However, there are not all rules would concern organizations. There are certain rules which are specific to the establishment of the regulator, the data privacy board, and then data protection board, and then there are certain rules which are specific to consent managers. Well, I'll talk about consent manager briefly at a later stage, but the remaining rules basically is what applies to organizations operating in India where this act is applicable. So what we have done is we have tried to summarize here only those specific rules which are basically impacting the organizations. So first and foremost is the expectation to have a privacy notice. The act as well as the rules together requires or mandates that at every point of personal data collection, there has to be a privacy notice displayed. The privacy notice has to be drafted in a particular format, and along with that, consent has to be taken for processing of personal data. So when we are taking consent, there are multiple nuances to the consent. We can be collecting personal data only for the purpose of providing services, and then we can be processing that personal data that we have collected for the purpose of providing services, and do a bit more, for example cross selling, for example upselling, and so on and so forth. So there is a need to have adequate consent in place for all the purposes that we are going to apply, or that we are going to adopt once the personal data is collected. Hence, the expectation is that all organizations should have an underlying consent for from the individual for the personal data that has been shared, so that the processing can be done in line with the consent. So that is one of the key requirements from the Act. Then, of course, there is a requirement on reasonable security safeguards. So once personal data has been collected by an organization, it is the organization's responsibility to ensure that security safeguards are in place to protect the personal data which has been collected. Now, protection of personal data can be done in multiple ways. One of the ways we were discussing some time ago was encryption. Then we had another requirement in the Act for called as masking. Then there is something called access controls. So there are multiple ways in which an organization can look at safeguarding the personal data that has been collected for the purpose of processing. And these rules have clarified that some of these safeguards needs to be implemented to ensure that the data remains protected. Now, even after putting in security safeguards, there are chances that data breaches happen. If there is a data breach, or there is a breach of personal data that has happened within an organization, there are two very specific requirements from the Act and the rules. The first and foremost being, as soon as the breach is detected, the organization is expected to inform the data principal that the data breach has happened. Okay. Similarly, the organization is also expected to inform the data protection board about the breach. And within 72 hours, the organization is then subsequently expected to update or submit a report to the data protection board with the details of the breach, investigating how the breach happened, what was the root cause, what are the mitigating measures, how many data principals got impacted, and so on and so forth. The timeline of 72 hours has been explicitly defined in the draft rules that has to be followed. The rules also, however, also say that based on written confirmation from the Protection Board, these timelines can be extended. However, it is expected that all organizations comply to a 72-hour timeline. There are some exceptions given to the state and its instrumentalities. When I talk about state and its instrumentalities, we mean to say that the Act not only applies to private organizations, but government entities as well, equally. And however, it comes with certain exceptions. So if there is a need for processing personal data or submitting personal data for, say, a legal purpose or a statutory purpose to a court of law, in all those cases, a consent may not be required for at the time of providing personal data. But those are only with respect to state and its instrumentalities. It does not. There are no exceptions with respect other than that to organizations operating other. Beyond its state and instrumentalities, other than some specific scenarios. So there are some specific scenarios. For example, if a child's personal data is processed by an educational institution, then there is no need to take separate consent. If a child's personal data is processed by a crèche for the purpose of profiling that particular child, then again there is no need to take a consent. So only the consent part. So there are certain specific exceptions to the provisions of the Act as which are listed down, and these listings are available within the 7 schedules that are there within the in the final rules. So we spoke about point number 4 here. Now moving to point number 5 about collection and processing of personal data of children and persons with disabilities. So one thing is very clear from the Act as well as the rules, that organizations cannot process a child's personal data or a personal data of a person with disabilities for optional purpose, for marketing purposes and so on. It is first of all, it is not permitted. Second, at the time of collection of personal data of a child or a person with disability, it is very important to note that the Act mandates that there is verifiable consent taken from the parent of the child or legal guardian of the person with disability. So the the responsibility of the organizations here increases multifold. It is not about only taking consent. It is about ensuring that in such scenarios, the consent provider on behalf of the child or the person with disability is the right individual, is either the parent or the legal guardian of the person with disability. And it has to be verifiable. The audit trail is required to be maintained in all such scenarios. The rules now require data fiduciaries to retain personal data for logs. So while there is a retention specific rule, Rule 7, which talks about what is the ideal requirement from a storage perspective. So it says that the expectation is that if the purpose is done, if the purpose is basically over, then it is expected that the organization should be purging or deleting the personal data that they have captured. So if you have captured personal data for the purpose of providing a loan and the loan is already paid up, it is expected that after the loan is paid, after the NOC is already shared with the customer, then there is no need to retain that particular personal information. You should be deleting it. You should be purging it. The particular rule is very clear to say that if the purpose is over, or there is a retention period, but it also provides some clarity that if there is a requirement by some other regulation, or there is a requirement by a legal framework or through any statutory requirement to retain the personal data for a longer period, then the retention has to be done according to the other applicable regulations. So, for example, organizations retain personal data of employees who have left the organization for at least 7 to 10 years because of the income tax regulations that is there, because of the retention requirement mentioned in the income tax regulation. So, in this case, even although the employee has left the organization, there is no need to retain the personal data. But because of the particular regulation, you may have to retain it, or you have to retain that personal data for a longer period of time. So there can be multiple other similar scenarios. We have to be mindful of all such applicable regulations. And if there is no such requirement or through any regulatory ask to retain personal data, then a decision has to be taken as to when the personal information shall be deleted. And these timelines of deletion needs to be conveyed to customers. Now, the act also, while we all of us here who have joined this organization, this webinar are representing some or other NBFCs, but I would like to call out something for all of our understanding, that if for social media entities, the act says that if a particular individual has not logged into their account for 3 years, then they can go ahead and delete their personal information with a 48-hour prior notice period. Okay, so the point that I wanted to elaborate was there are so many scenarios where individuals are like us. We end up registering for some or other services available on the web or a mobile app or through a mobile app, but we never use this information. Or use the particular service or use the website, or we have used it for a long time ago, and we are not using those services or websites anymore. So we can expect that through this implementation by virtue of the act and the final rules, all of those registrations would be deleted from these organizations, because this particular example that I cited has been clearly called out within the act. Okay, so I'll take a quick pause here for the questions that has been submitted. If I want to answer any of those, I'll try and do that. Okay, so I see that my colleagues have been responding to the questions, so I'll not take this point right now. We will take it up towards the end of the session. In my next slide, I have basically tried to summarize the act as well as the rules. While it may be an information overload as you look at it, but I have discussed most of the points during my previous conversation only. So as I said, there are 23 rules and 7 schedules. So what these rules entail, some of the key rules I have spoken about. I just want to highlight a couple of more points. There is a particular rule on cross-border data transfer. So for cross-border data transfer, the expectation here is that government eventually will notify at some point in time to which all country we will not be able to transfer personal data. But that list of countries is currently not available. So as from a compliance perspective, all we need to do is we need to be aware that our personal data that we are processing as an organization, in which all country they are stored. So there can be cloud service providers with their data centers stored in multiple other countries. So we have to know which all countries data center is this information stored, so that tomorrow, if at all there is a regulation, if there is a notification that comes in as a negative list of countries, we should be able to validate and accordingly take decision. Other than this, I have touched upon almost all the points, all the important points which are applicable to organizations. I'll not go into the details of this slide. Let me now discuss the timelines of implementation. As of now, we have 11 months. Sorry, 17 months and 24 days, a typo. There's 17 months and 24 days left to comply to the act, because the total net timeline that was provided was 18 months. 4 or 5 days have already passed. So in summary, I'm talking about 18 months, but there are 3 timelines which is mentioned in the act. When the act was released on 13th of November, there are certain provisions or certain rules that was basically immediately applicable. And those rules largely were on the establishment of the Data Protection Board, the appellate tribunal, the investigation and adjudication related clauses, definitions, and extent. So those are already applicable, meaning immediately after the act was notified, there are three more notifications that came in. One of the notification was that the Data Protection Board has been established. There are 4 members in the board, and the board will be board's offices will be located in the Delhi NCR region, or they will be operating from Delhi NCR region. Apart from that, the fact that they will be operating digitally was also communicated. So these through the subsequent notifications, the timelines of 13th November 2025 was already met. The timeline of 13th November 2026, which is 12 months from the date of notification, was only for Rule 4. What does Rule 4 entail? Rule 4 is about registration and obligation of consent managers. This is where I would want to talk a little bit about consent managers. So consent managers basically are entities which are going to evolve eventually by virtue of the act and the rules, which will be responsible for managing consents of data principals centrally. It will be like a CKYC kind of a concept that we have today. There is a central KYC done. All other organizations relies on the central CKYC database today, or many other organizations who have subscribed to the CKYC database, they rely on the information already available to provide goods or services. In a similar fashion, a consent manager would work. There will be a central entity where an individual's consent will be stored. That individual will provide all the details consent in terms of I am okay to do these things. I am not okay for any organization to reach out to me for these purposes. So based on the consent that is already provided, organizations can go ahead and provide their goods or services, or reach out to the customer for providing goods or services. But establishment of this consent managers would require more time, and hence 1 year's time was provided in the act. Now, moving on to the last piece, which is 13th May 2027, 18 months from the date of notification, there are a certain set of rules, Rule 3, Rule 5 to 16, Rule 22, and Rule 23. So all of these rules would basically become applicable, or the compliance timeline is 18 months from now. What does this mean? This means that the organizations have 18 months to comply to the requirements of the Act, because all the rules listed under the 18 months category is going to be the responsibility of the organizations. Okay. So this in a nutshell is about timeline. Apologies for the typo. It should be 17 months and not 11 months basically from now. So one piece I actually want to highlight here, before we move forward, there are 2 or 3 key terminologies which are coming from the Act, and we should be aware of those terminologies. The first and foremost being data fiduciary. So what is a data fiduciary? A data fiduciary is all those organizations which collects personal data for the purpose of providing goods or services. Those are data fiduciaries. Then there is a terminology called data principal. So data principal is basically individuals who is sharing personal data. Those are all data principals. They are referred to as data principals in the Act. And then there is a terminology for data processors. Now, data processors are basically organizations which are acting on behalf of data fiduciaries and assisting them in for providing services. So data processors are also organizations which will be processing personal data, but they will do that on behalf of data fiduciaries. And the Act is very clear to say that it is the responsibility of data fiduciaries to ensure that the data which lands up in the data processor's bucket remains protected. So we will increasingly see that if we as an organization are data processors, the corresponding data fiduciary is going to reach out to us to renegotiate the contracts that we have signed with them, because now they'll put the obligation on the data processors to ensure that the compliance requirements are addressed. So there are certain key obligations of data fiduciary. I do not want to go into the details of all of this, but I'll quickly I'll give a quick summary. So the first and foremost and most important obligation is to display a privacy notice and take consent wherever they are collecting personal data. And this is applicable to all data fiduciaries. Then one of the nuances for this is if the personal data which is being collected is of a child or a PWD, then verify if the person providing the consent is a legal guardian or a parent or not. That is 1 and 2. Uh, Once the personal data is collected, protect it. I have already spoken about some of the nuances to this. So that's what is number 3 here on the slide. Then valid contract. So basically between data processors and data fiduciaries, the contractual obligations needs to be updated. So to incorporate the requirements of the DPDP Act. Specifically Rule 6, because in Rule 6, it is mentioned clearly that data fiduciaries can obligate data processors through contractual obligations to ensure that the data remains protected. Data fiduciaries are also expected to provide a platform for the data principals to exercise their rights, which includes grievance redressal. So there are 4 rights which are basically part of the Act: right to nominate, right to leisure, right to access, and grievance redressal. So for each of these 4 rights, the data fiduciaries are expected to provide a platform or mechanism to the data principals to exercise their rights. So if a data principal wants to know what all personal data an organization is processing, then they can exercise their right to access and request for this information. And it is the obligation of data fiduciary to ensure that they respond to such requests. Similarly, if a particular data principal requests that delete my personal data that you have, then it is the obligation of data fiduciary to either delete it or convey the message why they cannot delete it, and those message can, if there is such a scenario applicable that they are not able to delete it because of the services that they are providing, then that has to be justified accordingly. If there is no justification, the obligation is there to delete the personal data. And of course, if there is breaches that happen, I've spoken about it again in detail, that if there is a breach, the obligation on the data fiduciary is to ensure that it is reported in a timely manner. The rules and the Act also then talks about a concept called significant data fiduciaries. So significant data fiduciaries have certain additional obligations. However, at this time, it is not clear, even from the final rules, that which all organizations would qualify for a significant data fiduciary. Okay. So the additional obligations of significant data fiduciaries is to have data protection impact assessment conducted in an annually. So once in a year, an data audit has to be done. Once in a year, a data protection impact assessment has to be performed, and it is expected from the significant data fiduciaries to formally appoint a data protection officer whose contact details should be made available to on their mobile apps and websites and any other communication made to the data principal in this regard, so that if the data principal wants to reach out for any queries or grievances, they can reach out to the DPO directly. So these are some of the obligations of data fiduciaries. I'll quickly move forward to talk about what changes we foresee in NBFCs post this mandate. So first and foremost, we foresee that for all NBFCs, there is going to be a need for all NBFCs to set up a data privacy team to manage all of these compliance requirements. There is a lot of work to do to achieve compliance, and there is a significant need to have a dedicated privacy team. While there might not be a dedicated privacy officer as it's required by the DPO or as required by the significant data fiduciaries clause, but a privacy team is needed definitely. Customer engagements, we definitely see that the customer engagements, the way lead generation is happening, loan applications, credit assessment happens, all of these the entire journey is going to go through a change because it has to be consent driven. So if there is a lead today which we are generating from for a prospective client who may take a loan, we have to have a consent to reach out to the individual to provide our services. Without consent, with this particular act in place, we will not be able to do that. Partner engagement model, as I said previously, also partner engagement models will change. We'll have to make partners, our vendors, obligate to some of the requirements because, and this will be applicable only to those partners who are receiving and processing personal data. Then comes your data, how the data usage, technology, and information security controls are implemented needs to be rethought. If there is a need to redesign the IT architecture, there might so be the case because of the way we are processing personal data, then NBFC will have to go through it. One particular piece I wanted to mention here was that for customer rights management, there is a requirement to have a separate function who will be then responsible to ensure that the people exercising their rights by virtue of this law is or this act is basically timely responded to. So we now have a 90-day time period for addressing grievance redressal because of the final rules. However, we have to work back on the timeline, and this can be a yardstick to measure what turnaround times we want to basically define for addressing customer rights. I'll move forward to the next section. Why do companies need to comply to the DPDP Act? Do not want to go into the further details. However, quick summary, there is a penalty section very clearly called out in the Act. The penalties can go up to 250 crore. So upon various scenarios, while these are not benchmark penalties, as in the data protection board would first do and conduct an investigation in case there is a grievance that is reported to the data protection board against a breach or non-compliance to the act. Subsequently, they'll take a decision accordingly. These are some of the indicative numbers which are coming directly from the act from a penalty perspective. I'll then move forward to some use cases that we have specifically from an NBFC standpoint. So there are three different categories of NBFCs that we have identified for these use cases. So the first and foremost being consumer durable loans, where on-the-spot EMIs are being provided. For example, if someone approaches any of the brick and mortar store to obtain to buy a white good or a mobile phone, instantly an EMI loan option is provided with an EMI base. So in that particular model of operation will now also require that we take consent as one of the initial steps before the EMI approval flow kicks in. Because if we do not have a consent, we do not have the right to process personal data. So we'll have to first take the consent, and the consent has to be clearly articulated, itemized. It has to be affirmative in nature, that the customer or the data principal is opting in for the consent, and in the absence of a mandatory consent opted in by the data principal, we'll probably have to take a decision that we will not be able to provide our services if the individual is not ready to provide consent, at least for the mandatory purposes for which it is needed. Maybe for KYC you would want to look at, for PAN we want to take into consideration because these information will be required to do a profiling from a credit risk perspective. So all of those have to be taken into consideration, and hence accordingly the consent and the privacy notice has to be drafted so that the consent basically step is added right upfront before the EMI approval flow kicks in, so that there is adequate consent and it can be demonstrated. That was one of the use cases that we thought we will bring up. When it comes to housing finance, see, housing finance are scenarios where the financial products have a long-term durability. So the loans go into 15-year, 20-year, 25-year terms. Over a period of 15 or 20 years, the personal data of individuals may change. An individual may change their address, communication address, mailing address, or the phone number might have changed, or there can be any other details that might change over a period of the time when these personal data elements gets updated, NBFCs needs to have, or organizations in this domain needs to provide a platform for the data principals or their customers to come and update this information voluntarily, because because it is one of the right to correction is one of the rights mentioned in the act for which is assigned to the data principals. When it comes to education loan, this particular case I wanted to bring up because there can be scenarios when the student uh, is less than 18 years of age. This is where you will have to take consent from their parent for processing their personal data, and you will have to have enough documentation to prove that the individual who has provided consent on behalf of the student is the parent, and it has to be, you will have to maintain that audit trail, maintain that record that you have verified it. So these additional steps are just a sneak peek into how things are going to change from your existing journey perspective when it comes to various types of NBFCs who are participating today. I'll quickly move on to our point of view, PwC's point of view on what is the overall methodology for implementing a privacy program. It all starts with enterprise-wide privacy. So you need to, organizations need to first establish a privacy framework, the policies and procedures as to how they want to take consent, where all they want to take consent, and so on and so forth. This framework will lay the foundation for the pillars of privacy, and that will start from customer protection. So your customer's data protection journey starts by identifying how the personal data is flowing within the organization. You are basically capturing personal data in application A, then the data moves into application B, then C, then after C, the data is basically lands up on a third party. So this entire journey has to be identified so that you now know where I have to take consent, where I have to take a decision as to how I am going to validate it. Between application A and B, B might be a rule engine to determine to who all individuals we want to
तो फिर मैं दुर्गापुर से
basically
मंगवा रहा
reach
हूँ
out to
17
for
प्लस
marketing
17
purpose.
34,000 हुए और दुर्गापुर में 32,000 का मिल रहा है, वहीं से मंगवा रहा हूँ।
Sorry.
हाँ
Coming back, so basically the point that I was trying to make was that there is a requirement to identify this workflow, because this workflow will determine how you are going to, where you need to take consent, where you need to validate consent, and which all touch points are there where you need to renegotiate your contracts with your third parties. So this particular data journey will help you determine that. Apart from that, basically, there are various tools available in the market from a privacy perspective, which you may want to implement to manage, to ensure that the consents are managed, stored centrally, and so on and so forth. And there is a concept called privacy by design. So in the change management stage, in the new application deployment stage, privacy has to be baked in as a part of one of the steps. Today, a lot of organizations already have implemented security by design, where a sign off from the corresponding information security officers are taken during the change management stage, and before go live, without an information security approval, the toll gate does not crosses. Something very similar has to be done from a privacy perspective as well. There are certain IS tools also, like DLP, IRM, organizations may have to consider to ensure that the personal data remains protected. Third-party risk management, I have spoken extensively about it, that organizations need to identify which all third parties are processing personal data, renegotiate their contracts, conduct periodic reviews to ensure compliance to the Act, and have a third-party privacy risk management framework in place to periodically assess the posture of privacy when it comes to sharing of data with third parties. And the last pillar basically is educating employees, vendors, and contractors alike. So we have privacy is a cultural shift. It needs to be propagated within the organization and outside the organization as well. Within the organization with employees and outside the organization. So just wanted to bring in one more point, that for any organization providing goods or services in India, we all know that the Act would apply, but let us be also very clear that for an organization, who are the data principals? Data principals are not only limited to the customers, but data principals are their employees also. Data principals
Faizan, you are on mute.
Yeah, I think he's lost his
Oh, so
Yeah,
network.
just hold. Yeah.
Yeah. So
all
I'll
right,
take
all
it
right.
up. So basically, what he was saying was data principals are all individuals. Okay, not only customers, but vendors, employees, visitors to your office. All of them are basically data principals. So that's what he was saying. Faizan, are you back?
Correct. Yeah, I'm back.
Yeah. Okay.
Okay. So the point that I wanted to make, you are absolutely right, Dinesh, was that only that employees, visitors, vendors, all of these individuals are data principals, and hence the act and the provisions of the act has to be implemented across the board with catering to all of these data principals. Uh, what is our point of view as to how an organization should take forward a privacy implementation program? This is simple string diagram. An anchor has to be there who will be responsible to ensure that the privacy program progresses. Then you need to have a vision in place, a set of frameworks that are compliant to the act that needs to be formalized. Then the business process realignment has to happen as to there are so many business processes that needs to get redesigned to incorporate the requirement of taking consent or validating consent before it is processed. And then subsequently the IT architecture and third parties has to be managed accordingly. What we have done is we have also tried to draw out an overall approach for a privacy program. So from a compliance standpoint, as we move forward, it has to be broken down into three phases: design, assess, and implement. You design your framework, which I just spoke about. You move to the data discovery stage, you identify what is the data flow and so on. Subsequently, you determine what would be your consent management strategy, where all you are going to take consent. Are you going to take optional consent? Is there a need to take any optional consent for marketing purposes or for purposes beyond the purposes for which you are going to provide your goods or services? Implement a privacy by design and conduct a risk assessment to identify gaps. Subsequently, move forward to deploy a technology stack like consent management solution, data principal rights management solution, breach management, and so on. Identify third-party risk management controls and implement those technical controls, and subsequently towards the end move into a managed services stage where basically you continue to monitor and sustain the overall program. In PwC, we have deep expertise across all of these stages. As we mentioned during our introduction phase only, there are more than 15 to 20 financial services organizations, let alone the organizations outside the financial services sector, where we are basically involved in their overall DPDP implementation journey. So that basically was all about the framework, the act, what does the act entail, how we basically implement it, and so on and so forth. I have a quick snapshot of some of the privacy tools that are available in the market. Let me be very clear. These are not all the tools that are there in the market. There are many tools which are there in the market. We do not have any particular preference to the tool. We work on all possible tools which are there. But the point of view that we wanted to make was there are so many modules which are there. Each of these modules may be required from an implementation standpoint as per organization's needs. We wanted to give you a view of what these tools are, what are the names of certain tools, and what modules are available in these tools, so that if you have to take a decision in future, you can accordingly basically refer to some of these solutions which are available in the market. Again, as I said, there are multiple other solutions also beyond these solutions which are there. I'll take a quick pause for any particular standouts that I need to answer, or I think Dinesh, you have been answering most of the questions. Thank you so much for that. So what we will do is, as a part of our next step, our next piece, we will quickly run through 2 or 3 questions. I'll display the questions on the screen, and people can post their answers on the Teams chat. if that's okay. So we will do it for one question. We will take 1 minute. So we'll have 3 or 4 questions here. So let's spend the next 3-4 minutes to.
Faizan, hold on. Let's not do it. There are some questions that are coming in.
Okay.
So I'll just pick up some of the questions. So should the DPO, I'm just taking it from the last. So should the DPO be a legal or IT person? The act doesn't mandate the qualification of the person. So he or she can be, any person in the organization. So that's where it is. But typically what we have seen is it should be somebody who has some legal orientation, some business knowledge, and some tech/security orientation, right? So it has to be sort of a combination of skills and capabilities, right? It's a very difficult combination to find, but yeah, it is what it is, right? Okay, so I didn't understand what is a GRO. Do you mean the group risk officer?
Grievance
Somebody.
redressal officer. Grievance redressal officer.
Yeah. Anybody can be the DPO. Anybody can be the DPO. That's not a problem. Okay. Can you elaborate more on data protection for PWD? So basically, PWD is person with disabilities. So person with disabilities will typically have a certificate from the government authorities with their which will talk about their legal guardianship, etc. As in who is the legal guardian, etc. So when you are basically looking at giving a product to a person with disability, you will have to consciously take that copy of that certificate and also verify whether the person signing off as a legal guardian is the same person whose name is there in that certificate, right? That is point number 1. Point number 2 is you have to take that data and flag it off as saying that this data is of a PWD and therefore not do any further processing of that particular data. Right. And when I'm saying any further processing, basically you don't send any messages, you don't send any emailers, etc. Right. So this is just to give some additional protection to children and person with disabilities.
There's another question. Who is consent manager? Can organization appoint the consent manager, or it has to be an empaneled third party?
No. So consent manager will be appointed by the DPB, Data Protection Board. So it will act on behalf of the customers. It will not act on behalf of the organizations. So organizations will have to interface with that consent manager to take the consents, otherwise which they would have taken it on an individual basis. Right. So which is why I had earlier also for an answer I mentioned that it will be like an account aggregator kind of a format. So basically instead of going to 10,000 people to take their individual consents, you can reach out to the consent manager and take all the 10,000 consents together. That's what the consent manager will do, but you cannot appoint the consent manager. The consent manager is an independent entity which will be appointed by the DPB, Data Protection Board. Appointment of the DPO is not mandatory for data fiduciaries. You are right. Appointment of the DPO is mandatory for significant data fiduciaries. However, we will recommend that somebody wears that hat of a DPO generally for a B2C and financial NBFC organization, right? Because there is a lot of work that the DPO has to do. So if there is nobody accountable for it from an organization perspective, then obviously things start falling through the cracks. What would be the relationship between consent manager and fiduciaries? Yeah. So basically, fiduciary will reach out to the consent manager and understand whether the consent, the data principal has given his or her consent to the consent manager. If yes, then they can take the consent from the consent manager and not reach out to the data principal separately.
So one interesting question, whether organization roles start at the time of passing of 18 months from notification date. I think it starts, it's already started, right? Dinesh, you may want to just elaborate on the timelines.
Yeah, so basically, see, 18 months after, that is on 13th of May, this act goes live. So from 14th of May, I can access all the rights as a customer or as an individual based on this act. So you should be ready as on 13th of May. 2027. So
the preparation starts from now.
Yeah. So the preparation starts from now. Yeah. So you don't have to appoint a DPO today. I mean, you can, but you don't have to. But as of 14th of May, for example, you need to have somebody as a DPO, for example. Do we need to take consent for existing PI data? Yes. All the timelines are same, 18th, 14th, 13th of May. Yes.
One question
No, so,
from my side.
Yeah, yes, ma'am.
So data fiduciaries and consent managers cannot be the same.
No. So see, again, I think there is a lot of confusion on this consent manager business. Okay. See, consent managers are independent entities who will work like, let's say, an NSDL is working on data sharing and data aggregation. Consent managers cannot be data fiduciaries. Right? And consent managers will be independent entities who will be appointed by the Data Protection Board. I can give you two names of two technology companies who are already in the pilots, doing the pilot with the Data Protection Board. One is called Baldor Technologies and one is the Geo Financial Services. As in Geo Financial Services ka subsidiary, not Geo Financial Services per se, but Geo Financial Services ka subsidiary. So these two are independent tech companies who are basically enrolled with the data protection. Whether data processor shall be enrolled with the Data Protection Board? No, not required. Role of DPO and data processor should be same. No. DPO is the data privacy officer and data processor is an entity which is servicing the data fiduciaries, which is organizations like you. Significant data fiduciary, DP board will not nominate individual companies. They will give a set of let's say parameters or classification criteria based on which automatically you will understand whether you are a SDF or not.
So another question, and I think it needs clarification. Do companies that provide consent management tools such as security qualify as regulated consent managers under the
No.
DPDP Act? Answer is no. So I think you may just want to clarify that.
Yeah. So these are see, there are two things when we are, I think we are confusing. One is a consent manager as an entity, and tools, consent management tools are only softwares. Okay. So softwares are going to be used by companies like you to manage your internal consents or for manage your consents or store your consents. Right? And consent manager is going to have his or her own software. For all you know, they might take that software from security.ai. I'm not saying no for that. All that I'm saying is it's a separate entity and they will develop their own platform. They will have their own software, whatever it is. But these two will be separate. Both of them can be security.ai. That's a different story. But both of them are completely separate. Do you expect RBI to come up with separate set of guidelines for REs? Now, there are two versions of this. One thought process is RBI is going to come up with a detailed set of guidelines for REs. Given that RBI is also asking some of the larger REs like banks, etc., saying that, what are they doing on the Data Privacy Act well before these rules came. Like even last year, they were starting to ask. So it is expected that they can come. But on the other hand, you might say that, given that this is under a separate regulator and this is not the turf of RBI, so RBI might just say that, please follow whatever the DPB is doing. So there are two versions of the thought process. I mean, I can't say which one will prevail. Data fiduciary and data processor can be the same. So a company can be a data fiduciary for its employees because obviously it is, but a data processor from its business standpoint. Okay, again, the same question on consent manager.
Yeah.
Consent manager is a separate entity which will act on behalf of customers, right? And take a general consent from customers. You as data fiduciaries can take customers' consent separately, or you can reach out to the consent manager to take their consent, right? But at the end of the day, you will also have to store their consent in your, let's say, databases, because tomorrow if there is an audit or tomorrow if there is a, let's say, an assessment from the DPB, you will have to demonstrate the fact that you have validated the consent from the consent manager.
So they look at consent managers as your depository participants or RTAs in a very crude manner. Of course, the roles and responsibilities are very different, but they would basically act as the centralized independent entities appointed by the board, DPDP board, for managing consent for the convenience of the individuals, that is the customers, so that
Yes.
the customers don't have to repeatedly give consent to say 10 lenders, 10 other insurers, or we engage in multiple transactions, right? Financial, non-financial. So the consent manager's job would be to centralize all of that for us, and that will be ease of doing business for us as well as for the service providers.
Yeah. One other question which is important: what challenges might arise for a consent manager in ensuring interop between across diverse platforms? Yes. Now, this is the question that we have also been asking the ministry, saying that, what are all the, how will a single consent manager take the consents as required for, let's say, a Netflix versus a Zomato and versus a, let's say an NBFC, right? Because these are three different questions from personal data, three different forms of consents that will be required. So how will a consent manager be sort of, managing consents across, let's say, three diverse entities that I just named, right? So that is a challenge. And similarly, it will be a challenge, therefore, for fiduciaries also. So, for example, if you want consents for 10 data elements that you are taking from customers, let's say, for example, his customer's address, also customer's income statement as well, let's say customer's house, housing loan or whatever. But some of these will not be taken by a Zomato, right? Zomato needs only the name, address, and phone number. They don't need anything else, and maybe email ID, right? But they don't need an income statement. They don't need anything else, right? So it will be for you, for example, you will have to assess what are the fields that the consent manager is giving that consent for and whether that is adequate for you. If not, then you will have to again go and ask that consent from the data principal itself. At least that is what we are envisaging right now. But obviously, as the consent managers come up and as they demonstrate the fact that, what are the consents that they are taking for, this clarity will emerge.
Can you please explain a bit on validating the consent from the consent managers?
Okay, so see, basically, if you need to send a message to a particular customer, you will have that consent in your own database, let's say, if you have it, or if you don't have it, you will reach out to the consent manager, which is a separate independent entity, to understand whether that customer has given consent for marketing messages or not, right? So you will have to validate whether that consent exists either with you or with the consent manager, and only then you can send the message.
So do the customers get a option to remove consent on consent manager's platform, or do they have to come?
Absolutely.
No. They can remove the consent from the consent manager's platform as well.
So,
and just to clarify, we need to take consent from all existing data principals onboarded by 13 May 2027. That's correct.
Correct, yes.
Are there any conflicting rules between data privacy and data localization with reference to data storage? No. So basically, all the current rules or sort of circulars that are being given by RBI will still prevail.
Correct.
Right? It will supersede the Data Privacy Act if it is more stringent than the DPDP Act.
Just wanted to check, say, if someone has revoked the consent from the consent manager, which is provided by the Data Protection Board, what if that consent is required to provide the services? Can we stop the services if someone has stopped, if they don't want to provide the consent?
Yes. So basically, see, again, this was a standard question in a lot of financial services institutions, right? So what we are, the practical way, the way we are sort of recommending is there are certain consents which they will have to give as a mandatory consent, right? So if that consent is not given, then you cannot first start off with providing the service to that particular customer, or in your case, the loan to that particular customer itself. But having said that, if that customer, coming back to your question, if a customer has given a mandatory consent, he cannot remove that mandatory consent, because that is why it is called mandatory consent.
Yeah. So I think we're just about to hit the 4 o'clock and being conscious of time. There is just 2 more questions. Any specific provisions for obtaining consent from illiterate borrowers in the context of data privacy? I'm not sure if illiterate borrowers would be digitally savvy. So maybe Dinesh, you can answer that.
No, so it doesn't matter whether they are digitally savvy or not, right? If we are digitizing their data, then we need to
Correct.
take consent. It's very, very simple, right?
Yeah.
So we will have to figure out a mechanism where we can explain to them and take an agreement on the consent. And if that means that, so for example, in the Faizan, you can log off for the next call at 4. I will join you. So sorry, coming back, so there is a provision in the act which says that all the notice and consent should be in any of the 22 languages as per the Schedule 8 of the Indian Constitution. So basically, if you are saying that, if a person is illiterate, maybe you might explain to him in his or her own language, and then take his signature or his thumb impression, like we do it for any other transaction. Because we will anyway be taking a signature or thumb impression even for our own transactions also, right? So we will do the same way.
Great. Thank you. Thank you so much, Faizan, Dinesh, and the entire PwC team. It's been a very enlightening session, but at the same time, quite heavy. I know our members would obviously have a lot more questions, and therefore we are here to help you navigate through this new act and the new regulation that has come into picture. Heartfelt thanks to Mr. Mahesh Chakra, Chairman, for your vision in making data privacy a strategic priority for FIDC and helping us understand its importance beyond just compliance. The PwC team for your expertise, practical examples, and clear explanations, and your patience with which you've answered and taken the care of Dinesh, particularly you responding to every single query on the chat. It's really, really appreciable.
Yes,
thank you very much. Yeah, thank you very much for that. It's been really engaging.
Can they accept that if the questions are received on this for next 3-4 days, they can give reply by email in writing? You can extend
Yeah. So if you can consolidate all the questions, Priya, I can answer those.
Tell the members you can send but give an upper limit of 3 to 4 days. Okay.
Yeah. And thank you also for our members
can
for
we
your
get this
excellent
presentation?
Questions. Yes, you
yes,
will,
yes,
sir.
we will send it through, send it to Priya, and then she can forward it to all of you.
Yeah. Now, in terms of next steps, please watch out your inbox for a brief feedback form, which will also have a field for updating any questions you have, which probably has remained unanswered or clarifications you need. We will be sharing today's presentation and the recording, and of course, updates on any other upcoming sessions that will be there. Thank you, everyone. We have 18 months left, actually less than 18 months, I think 17 months and 24 days. So let's use this time wisely. FIDC is here to support you with knowledge, tools, and community of peers and partners like PwC who would help us navigating these challenges. Thank you once again for your time and participation.
Thank you.
Yeah.
Thank you.
All the best.
Thank you.
Bye-bye. Thank you.
Bye.